Hi everyone, it's Amy here from the blog I Think Therefore I Teach. Welcome to your next Criminology instalment. This is for Unit 3 and it's assessment criteria 1.4. Right, let me make myself smaller. Okay. Assessment criteria 1.4, then this is examine the rights of individuals in criminal investigations. In this topic, you need to examine the rights of individuals including suspects, victims and witnesses. This is a nice short one, low marks. So the first thing I got my students to do is I got them to think about the rights of the suspect, the victim and the witness. What rights do you think a suspect should have? What rights do you think a victim should have? And what rights should a witness have? So the rights of a suspect, first and foremost, on their arrest, a police officer can arrest a suspect without a warrant if there are reasonable grounds to believe a person is committing a crime, has committed a crime, or is about to commit a crime. So even if there's just reasonable grounds to suspect them, you can arrest them. A police officer must inform the person that they are being arrested and for what reasons. I'm arresting you for blah, blah, blah. The police officer will then caution the person. Anything you say will be given as evidence, etc. What rights then does a suspect have when they're being arrested? So there's a video there that you could watch, but if you just YouTube it, there's lots of very good things on YouTube to help with the process of how suspects are arrested and dealt with inside the police station, for example. What are stop and search powers? So what stop and search powers does a police officer have? And what is the wording of the caution given by the police to the suspect when being arrested? So I got my students to look into those two questions and research them as well. At the police station then, a suspect is handed over to the custody officer, who makes sure that they are treated in line with the law and given their legal rights. So you are still, even though you are a suspect, you are suspected of doing a crime or about to commit a crime, then you are still treated though in accordance with the law. The custody officer reviews the length of detention, how long they're going to keep you for. Usually you are released within 24 hours of arrival. In the case of indictable offences, so of serious offences, a further 12 hours can be added to this, so 36 in total. Longer detentions, though, you need approval from a magistrate's court, and they can grant up to 96 hours. So that's especially if you're then looking for evidence to be able to arrest them and charge them. So obviously that length of time is to interview the suspect, but also to gather the evidence that you need. Three main rights that you have under PACE, Police and Criminal Evidence Acts of 1984. The first is 56 PACE, a right to have someone informed, so that's your phone call. 58 PACE is a right to consult a solicitor in private, so you can have a private room where you can discuss with the solicitor what's happening. And then a right to consult the codes of practice, so you can attempt to read the codes of practice of basically how you should and should not be treated. Fingerprints and your that should be DNA, not DVA. DNA from a mouth swab are taken. So, and then they will be put onto the system. What rights does the suspect have then when in the police station? So I get my students to then look into what other rights in PACE are relevant to the suspect. And then get them to watch again this clip of what happens after, it should be you are, yes, so not your, you are arrested. So this is what happens to you once you are arrested, and you can watch once more the process that they go through. In the interview in the police station, anyone detained may be questioned by the police. Safeguards are in place to protect the suspect, such as all interviews are recorded and sometimes video as well. This not only though protects the suspect, it also protects the police officers so that everything is then recorded and can be used later in court. I think it was one of the cases, I can't remember exactly which one, but I think it might be Stephen Lawrence. One of the cases, either Stephen Lawrence or Damilola Taylor, where the suspects were talked to for some reason without being in a proper interview situation. So they said things that then couldn't be actually used because there was no actual record of them. You have a right to legal advice. You are entitled to a solicitor present. You have a right to silence, because I think this is the rights. You have a right to silence. You may remain silent. No comment. However, remaining quiet may be used against you in any trial, as this is failure to mention something crucial to their defence, because don't forget that the wording is something which you may relate to rely on in court. Staying quiet and saying no comment doesn't necessarily help you, because if there is something that they need to know and they're going to find out, owning up to it early on is important, because actually then it can be used, your no comment can be used against you as well. Appeal. If you are tried in a magistrate's court, the defendant has a right to appeal against conviction if they plead not guilty. So if you plead not guilty and then you are convicted of it, you can appeal. You can also appeal against the sentence to the Crown Court. So you can appeal that you're not guilty while you're being convicted, but you can also appeal to the sentence of how long they're going to detain you for, or the sentence that they are saying you're going to get. The case could be reheard by a judge and 2 magistrates. Any further appeal must be given leave or permission and must be on a point of law. This comes up in a lot more detail in a few topics' time. If they are tried in Crown Court, the appeal is not automatic. You don't automatically get a chance where you're there and then to appeal it. Any leave must be sought, though, within 28 days of the decision. So if you do want an appeal, then you have to do it within 28 days. Appeals against sentences and convictions is possible, but only on grounds of it being unsafe. Only the appeal, is heard, not the full retrial in the Court of Appeal, and Criminal Division has 3 judges at this point. Only cases involving a point of law of public importance would be able to appeal further to the Supreme Court. So if it was a matter of huge public importance that this person or persons should not be let out, then then the appeal can go further to the Supreme Court. Once again, as I said, this comes up in more detail, I think, around 2.2. This goes into a lot more detail. So at this stage, you will need the rights. You don't need the actual step-by-step. The rights of a victim. The rights of a victim are contained in the Code of Practice for Victims of Crime, or Victims Code. This was established by Domestic Violence Crime and Victims Act of 2004. The Research Victims Support, so this was the Research Victims Support Group. I got my students then outline the Victims Code, what information should be given to the victim when reporting a crime, and what support should be offered. During a trial, what information does a victim have the right to? It's spelt wrong again, I'll change that. Does a victim have any rights with regard to the outcome of a trial? And so the rights when reporting. This was written confirmation of the crime reported. They also have a crime reference number and contact details for the officer dealing with their case, so that they can be kept informed about the progress of their case at all points. They also can make a victim personal statement to be read out in court. So they have many, many rights when reporting. They also have rights during an investigation. They can hear when a suspect is arrested, charged, bailed or sentenced, and again that's really important, because just imagine if you've had a problem with somebody and you've gone to give a witness statement, or you're the victim of it and you've gone to give a statement, and then they're on bail and you see them walking around and you don't realise, that can be extremely traumatic. So it's very, very important that you are kept up to date with these things. Also, you have a right to privacy, that only information is shared with the media that has had permission from the victim. Once again, this is not something that's always happened. Sometimes things have been leaked, but this is not a good thing. You know, the victim does have rights, that they have a right to whatever they say in a police station stays between them unless they're happy for it to be shared for the benefit. So, for example, Damilola Taylor, James Bulger killing, these actually then went to things like Crime Watch, etc., and they were able to bring out private information like baby pictures in order to draw the public in to help them find who did it. The rights of a victim, rights relating to trials. They can apply for compensation given to the victim by the court for personal injury or damage to property. The victim of violent crime could apply for Criminal Injuries Compensation Authority as well, CICA. They are assigned a witness care officer who will support them before and during the trial and will inform them of the verdict within 24 hours. So this is the person that basically helps them, monitors them, keeps them up to date. If you are a vulnerable victim, you also have other rights. You can apply for extra help when giving evidence in court. So, for example, a judge can take off his wig if you can't be around someone wearing a wig. They can also give video recordings or be behind a screen. They are entitled to receive information more quickly and specialist advice and support. And again, you can watch the Victims Code on YouTube. Finally, the rights of a witness. I get my students to watch that clip of Going to Court Step-by-Step Guide to Being a Witness and make notes on what to expect throughout the court process, the journey a witness makes from making a statement right through to the criminal court process and after the trial. The witness charter containing the standards of service a witness can expect in a court case. So the witness charter is what has everything of how a witness will be dealt with. The standards include: there is a main point of contact for information about the case. They're able to claim expenses for travel or loss of earnings incurred by the court. So, for example, if you are a witness and you see something, but you have to go to work, this is your normal life still. Life still goes on, and so you are paid for travel expenses if you have to go a long way. You might be on holiday and see something. You still have to go back to the Crown Court in that area or the magistrates in that area, and so they might have a long distance to travel. They might have to take time off work to do this. You might be in court on several days or several appearances, so this is then compensated. Special measures again if you are a vulnerable witness. Complaints procedure if standards are not followed. So these are dealt with by Parliament Ombudsman, and the CPS Crown Prosecution Service also provides information, assistance and support to victims and prosecution witnesses. Finally, give a brief outline of what the Witness Charter does, what is the role of the Witness Care Officer, and what rights does a witness have during the police investigation on arrival at court, in the courtroom and after the trial. So I've touched upon them briefly, but you might want to get a little bit more information and depth and detail about those. Don't forget, this is a short, small marker, and you don't have a lot of time for this one. So this one is not one to spend a long time on in your controlled assessment. Fabulous. I hope you found that useful. Please don't forget to give me a thumbs up if you liked it, or don't forget to subscribe so you never miss out on a new upload. And also feel free to comment or ask any questions underneath, and I will try and respond. Otherwise, thank you very much for watching, everybody. See you next time. Bye for now.